Thank you, Kevin. And thank you to everyone for showing up today. Too nice to be here, but I appreciate that anyways. I'm going to talk about qualified spousal trust. I'm going to give you a little background on it. Feel free to ask questions along the way. I'm not tied to the presentation per se. So if something comes up, I'm happy to do it. My name's Mark Temkin, as Kevin said. I'm the managing partner of Reisman-Berger law firm in Clayton. Kind of specialize in very aggressive representation of our clients and very creative thinking, and the qualified spousal trust is really part of that. This was actually enacted in Missouri in, it's almost been 3 years, and it's a function of our having drafted joint trusts for about 20 years. Joint trust was really something that a lot of lawyers didn't want to do, didn't believe in it, didn't believe you could get the tax benefits of it. We worked our way through it. We were comfortable with it. We got kind of tired of having lawyers start taking pot shots at the trust and saying, this can't work in Missouri, it can't work in Missouri. So one of my partners is a lobbyist, David Claridge. Came to me 4 years ago, came to me and said, Mark, we had a change in the legislature. We probably can get something passed if you're interested. Is there something you'd like to do? I said, well, you know, we've been doing these joint trusts for a long time. I'm kind of tired of having lawyers taking these pot shots. Why don't we legislatively validate it? Why don't we try to get that passed and take the risk out of it for our clients? Because our clients shouldn't be at risk. That's not the position that we want them in. So he said, well, that's a great idea. Put something together. So I put together a bill, took it up to Jeff City, and it was going great until they decided they had to ask the Bar Association about it. As you can imagine, that didn't go over well with the Bar Association, since I'm not actually a participant in the Trust and Estate Division. So we got stuck in the legislature. I got invited to the Trust and Estates Committee meeting, and I listened to them rail on this crazy lawyer from Clayton who had the audacity to draft a statute relating to trusts. So I raised my hand and I said, I'm that crazy lawyer, and let's talk about this. So in fact, we spent about an hour talking about why qualified spousal trust is a great idea. And it wasn't called a qualified spousal trust at that time. It was actually called the tenancy by the entirety trust. So we got done with the meeting. Everybody agreed it was a good idea, but the reality is we couldn't agree on the language of the statute. So we agreed to put it off that particular session. We'd get together during the interim, and we would work it out. So we got together with the lawyer who usually drafted most of the legislation for the Trust and Estates. We asked him, Scott, what's your issue with this? This is too good of an idea for people to be opposed to it. And he said, well, you know, we like the idea, but we don't like the name. If you call it a qualified spousal trust, we get behind it. Hence, we have the name qualified spousal trust. So in Missouri, we now have statutory authority for joint trusts, and specifically the asset protection and the tax benefits that were in question before. People were doing joint trusts, and people were comfortable, I was comfortable, that you had the asset protection that a joint trust was supposed to give you. But there were questions about it. We took the questions out. So if you have a joint trust, even if you haven't qualified as a qualified spousal trust, it is retroactive. If you met the criteria, your trust will be treated as a qualified spousal trust. So that's somewhat helpful. Basically what the qualified spousal trust does is it allows a husband and wife, and this is really only applicable to husbands and wives, to transfer tenancy by the entirety property into a trust, get the asset protection that you had when you had it as tenancy by the entirety, but be able to do whatever tax planning you couldn't necessarily do before. So it eliminates a tax uncertainty that used to exist. There were all sorts of questions of whether or not you could use the unified credit of both spouses or not. That's all gone with this. And we created this legislatively statutory entity called the Qualified Spousal Trust. And there are three types of these. The first type is probably the traditional joint trust that many of you may have seen, maybe you can have them, where you take the assets, you hold them as a pot, and it passes directly to the survivor. That's the traditional joint trust. Our joint trust worked a little bit different, and intentionally to be able to get the tax benefits. But the criteria is that each spouse has to be able to receive distributions of income during their lives. That's sort of consistent with the tendency by entirety nature. But the difference is that nothing prevents you from splitting the trusts apart at death. So you can actually take advantage of tax planning if you need to do it. Some of that has been eliminated with the concept of portability, and I'll get to that in a little bit. But this is the traditional joint trust, and they, whoops, no. Okay? Which is better?
Could you turn the volume up also a little bit too, please?
I can try. Is this better?
Say a few more words and we'll see.
Well, all right. Let's see if we can't get this. How about this? That's better. So when you create this qualified spousal trust in this format, you have the choice of just having a continuing existence for the survivor, or you can actually break it apart into the traditional two-trust format, taking advantage of the unified credit when the first person dies. The second version, and this is actually where, if you want to say, the change in the law really exists. The traditional estate plan, probably most of you have, if you have trust, this is probably what you have. You've got two separate trusts, husband's trust, a wife's trust, and the idea is to take advantage of both parties' unified credit. And then you do your planning accordingly. The problem with this, it's not a problem, this is what we always did, is you don't have asset protection. So you forfeit the asset protection that you had when you owned the property together in order to get the tax benefits. Now we can actually create a qualified spousal trust that splits into two trusts. Looks exactly like what you have now, except you've picked up the asset protection. And for anybody that's concerned about getting sued, that has a lot of value. But once you get it in and set up, it's going to look and feel exactly like your separate trust. The third version is actually a combination of this. I can't tell you why they felt it necessary to actually have this third version, because I think it was kind of inherent in the first two. But if anybody's been involved in getting legislation passed, you learn very quickly you have very little control over the actual end product. You have a lot of control in maybe how you go about it. There's an old saying, you don't want to see how sausage is made, you don't want to see how legislation is made. So in this version, basically, you have the separate trust, and then you have the joint trust. And the appeal of this for people was, particularly a lot of people didn't like the idea of separating their house. So you could kind of hold the house together, but then separate more of the investment type assets. So that's the reason for it. It's a good idea to have it. I just think you had it, whether you had it or not. So how does the qualified spousal trust kind of compare with the traditional plan? Well, traditionally for a husband and wife, if you had assets over the estate tax exemption, now that number is $5,340,000, you would have two separate trusts, one for husband, one for wife, to try to maximize both parties' unified credit. The new qualified spousal trust allows you to transfer the property into this qualified spousal trust, but keep the asset protection and still get the tax planning that you were doing with the two separate trusts. So if you compare, I don't know how familiar people are with tenancy by the entirety, but basically husband and wife, if they own property together, they own it as tenants by the entirety in Missouri. And tenancy by the entirety gives you asset protection. If one of the spouses gets sued, a creditor can't get at assets that are owned as tenants by the entirety. They can only get at assets that are owned by you individually. So that's sort of the key feature. Tenancy by the entirety was always the cheap version of asset protection. You could go to a doctor and say, well, just hold your assets collectively as a husband and wife. When you get sued for malpractice, they can't get at those assets, at least while both of you are married. So that forms the basis. Tenancy by entirety gets you about 90% of the way, 95% of the way towards asset protection. The downside of tenancy by the entirety is that by law, the property automatically passes to the survivor. And that lost the unified credit of the first person died. With portability, I'll get back to that again, that's not as big of an issue. But the survivor would control all of the assets, and that may or may not be what's desired. So, in tenancy by the entirety, all the assets are going to pass to the survivor. In the qualified spousal trust, while the spouse can get the benefits of all of the assets, they don't necessarily have to have total control of all the assets, nor do they have to necessarily go to the spouse. That, of course, can protect against what happens when the spouse remarries, second family, all of the traditional things that occur. The estate tax exemption is at $5,340,000. Combine the two, you can have a $10,680,000 estate, no estate tax. We enacted a couple years ago the concept of portability, which says that if a spouse dies and you do all the things you need to do, if somebody didn't use their full portability, their full unified credit, the surviving spouse can use the part that's not been used. That kind of helps a lot of the joint asset situations because you can now have collectively $10 million plus no tax. But what you don't know is where that's going. Portability is a new concept. I think it's here to stay, but I gave up my crystal ball when they actually got rid of the estate tax for a year. I thought there was zero chance of that ever happening. So I no longer think I can predict where this is going. Also, if somebody remarries, you lose the unified credit benefit of the portability that you had before. So there are ways to plan for that before you get remarried, but if you don't, you might lose it. If you use the qualified spousal trust, you're certain you're going to use both parties' full unified credit. So that's an advantage. Tenancy by the entirety has probate possibilities. People think, I own as tenants by the entirety, no probate. That's not really true. There's no probate when the first person dies, but there will be probate when the second person dies. So unless you've got it into some sort of trust, you're going to go through a probate. Qualified spousal trust avoids the probate. The claims of creditors. So in tenancy by the entirety, the benefit is that while both husband and wife are alive, the creditors of one can't get at any assets. That's the good part. When one spouse dies, the property passes to the survivor. Now that survivor's creditors can get at all of it. Qualified spousal trust, first of all, it gives you the ability to split apart the assets. So at worst, there's half. The maximum amount would ever be half. Nothing while both spouses are alive. When one spouse dies, there's a possibility of half. with proper planning, you can make it 0. But it takes some planning to get there. Traditional asset protection trusts, I don't know if people have gotten into that or not, still have a place. And some of these, you can actually get even better protection with certain traditional asset protection trusts than the qualified spousal trust. The qualified spousal trust gets you so far without giving up control. The traditional asset protection trust, you have to give up control. The qualified spousal trust, you don't, because you control it. So that's a big difference. Who should use a qualified spousal trust? Basically anybody. If you're married and you have any concern about asset protection, you should be talking about qualified spousal trust. It's a relatively easy, straightforward method of assuring the asset protection, assuring your ability to take advantage of the tax situations. The obvious ones, doctors, lawyers, people who have the potential to get sued, those are really easy. Your financial planners, anybody who has a chance of being sued in their individual capacity should be concerned about it. But the reality is that anybody can be sued. You can be in a car accident and get sued. Why not protect your assets? It doesn't cost really anything more to do a qualified spousal trust than your 2 separate trusts. One of the questions which always comes up is, what about, this is a second marriage, I've got premarital assets. If I combine them, I'm going to lose my ability to keep them separate in the event of divorce. And that's a valid concern. But you can address that with a postnuptial agreement. So even in that situation, if you're willing to address the hard issue of the husband and wife relationship, you shouldn't be afraid of putting the assets in a qualified spousal trust, because if you go back, remember, you can have these 2 separate trusts. You can end up dropping the assets into the qualified spousal trust and then end up with the separate assets in the separate share of the person who had the premarital assets in the first place. So it's really an incredibly flexible vehicle. So what are the key advantages? Obviously, number 1 is asset protection. That's really the whole reason we came up with the joint trust in the first place. It's the reason we came up with the concept of the qualified spousal trust. Giving our clients asset protection, something that most of our clients, at least, that's something they're very interested in. Avoidance of probate. You can avoid probate using your revocable trust, but it's a feature that comes with the qualified spousal trust. Avoiding probate, always recommended. It's a waste of money to go through probate. It's just a waste of time, it's a waste of money. So if you get nothing else out of this and you don't want to do a qualified spousal trust, think about other trusts, things that keep you out of probate. Advantage, the ability to use both spouses' estate tax exemptions while maintaining. You still get that. And then some people are concerned, well, what does this do if I get divorced? Well, the statute specifically says it doesn't do anything. It's going to have, the fact that you've got assets in the trust, they'll be divided up by the court, just the way they would have been if they weren't in the trust. So you're not really losing anything by putting it in here. Any questions? Can't be that clear.
And you're talking, this was passed in Missouri.
Yes.
This applies to federal also?
Well, it applied from the federal, the reason that we passed this 2 separate trust share was to comply, to make it very easy to conform with the federal, how the federal estate tax fits. So yes, it fits there. From a federal standpoint, it is a Missouri authorized trust. Now, actually, it says it's a husband and wife transferring tenancy by the entirety of the property into it. There's a real interesting question. If you live in one of the other states that allows tenancy by the entirety, could you create a trust in Missouri and take advantage of the asset protection? The answer is actually we think yes. But it is a state form of trust but designed to take advantage of all the estate tax, federal estate tax type provisions. Yes, ma'am.
And question to that, do you know if Illinois,
Illinois does not have tenancy by the entirety. So this won't help, except if you took your assets, had them under control in Missouri. There are ways to kind of bring it in, but Illinois does not recognize tenancy by the entirety.
okay, so if I set it up in Missouri and then retired to Illinois, would I be okay, or would I be?
No, that you'd be okay with. You'd be okay with that.
As long as I set it up in Missouri before I move.
Right. That you should be totally fine with. Yes?
Talk a little more about the retroactive to a joint, if I have an existing joint trust,
Right.
do I need to go back and redo it or change anything, or can I just assume that it's,
Well, you should never assume.
well, right?
But the statute was specifically drafted to validate a trust that met the criteria. So if your trust meets the criteria, which is basically, if it's a traditional joint trust, which is sort of held collectively, where both spouses get the right to income, whether it's mandatory or discretionary, through your lives, it would qualify. And then you would be governed by it. Now, there's actually been an interesting case. There's only one case on this, and it just came down. And it had to do with bankruptcy, where somebody was trying to argue that their trust, which actually was created after they filed for bankruptcy, should give them protection. And it wasn't going to work under any circumstance. But it was an interesting argument. Yes?
Are you allowed to title everything in the name of the trust to keep it out of your individual names?
Well, you will title everything in the name of the trust. You would title it all in the name of the trust. And whether or not it's a combined trust or separate shares, like mine is called Mark Share, if the Mark Leslie Temkin qualified spousal trust, because I've got a separate share version.
So you're making yourself an LLC then?
Similar. Ownership of the LLC, if you own it personally, is going to go through probate. Ownership of your trust avoids probate. So you get some asset protection from an LLC, but you don't avoid the probate in the LLC. The trust does. There are other issues with LLCs because creditors can get charging orders. But that's a whole different discussion. Yes?
We've got wills from a number of years ago, but we don't have trusts.